everybody. Welcome. We're going to get underway. As most of you know, I'm Craig Snyder, the President of the World Affairs Council of Philadelphia. I want to thank you all for being here with us today. Not one of our usual venues, but we want to try new things and offer people the opportunity to see new spaces in town. Start with our obligatory announcement. Before we begin, really would like to ask everybody to silence your cell phones if you haven't already done so. However, as always, we encourage you to tweet after our speakers' remarks. We invite you to like the World Affairs Council on Facebook if you haven't already done so. I want to go very quickly through what I think is an exciting lineup of additional speaker events we have planned for October and November. On Thursday of this week, the Council will join the Consular Corps Association of Philadelphia and the World Trade Center of Greater Philadelphia in welcoming the ambassadors of Latvia and Lithuania and the Deputy Chief of Mission of the Embassy of Estonia, coming to discuss the Baltic region and the threat many people see to that region from a resurgence of Russian military power in the area. Next Wednesday, 14th, the Council will present its prestigious Atlas Award to the Human Rights Project for Girls, acknowledging its critically important work against human trafficking. And our award will go also to our outgoing Chairman of the Board, John Walsh, recognizing his great contributions to educational and charitable initiatives in the Philadelphia area. Our keynote speaker
that... Craig, could you move that mic closer to your it's really hard to understand you.
Sorry. Okay, I guess we're going to... better. Better, here we go. The keynote speaker for our Atlas Award program on human trafficking will be Senator Amy Klobuchar of Minnesota, the co-sponsor of the Justice for Victims of Trafficking Act, which is the prevailing American law on the subject. And for any of our young professionals in the audience, the Council is participating in Young Involved Philadelphia's upcoming State of Young Philadelphia event. We'll be hosting a panel and quizzo on global affairs education in Philly in partnership with the Foreign Policy Research Institute and the Global Philadelphia Association. Next, as I told you, it's a packed schedule. We have on October 21st, Democratic political insider David Brock, who will be discussing his provocatively titled new book, Killing the Messenger, the Right-Wing Plot to Derail Hillary and Hijack Your Government. We're not quite sure where he stands on the upcoming election. If you come, I think you'll be able to sort that out. And then on November 17th, and I'll stop with this one, we have a former ABC News icon, Ted Koppel, coming to the Council, who has recently written a book on the potential of future cyber attacks against the United States and paints, I must say, a rather bleak picture of our preparedness, so I think it's an important conversation for us to have. These events and the Council's citizen diplomacy trips, along with the support of our members like you and our corporate partners, enable the Council to offer its most important programs to a diverse group of over 2,200 middle and high school students in over 90 schools throughout the Philadelphia area, fostering the skills and sensibilities that they will need to live in a global economy. We have with us today a group of students from the Bodine High School for International Affairs. Want to raise your hands, guys? Let's welcome them. And now on to tonight's program. This program is part of the Council's A.J. Raju Millennial Membership and Program Series, made possible by the support of our board member, A.J. Raju. He couldn't be here tonight, but I want to thank him for his support of this series. So as we all know, 2015 was a most significant year so far for the Supreme Court. with decisions handed down on such contentious issues as same-sex marriage and the second major case to challenge the Affordable Care Act. But the Roberts Court has already seen a great number of controversial cases since the Chief Justice took that position, issuing rulings not only on those issues, but on abortion, gun control, affirmative action, capital punishment, and free speech as it relates to campaign finance, and many, many more issues. And of course, the new Supreme Court term began yesterday, the first Monday in October, and promises to be, again, very important for the future of American law. With us tonight to discuss the court, its justices, and its decisions is Professor Kermit Roosevelt. Professor Roosevelt teaches at the University of Pennsylvania Law School, focusing on constitutional law and conflict of laws, and he has written a number of books exploring these topics. Please join me in welcoming Professor Roosevelt.
Thank you, and thank you all for coming here. So we're going to talk about healthcare, marriage equality, and campaign finance reform. I'm going to do all of that in 15 minutes. And I can do it that fast because I have a simple yet comprehensive framework for evaluating Supreme Court decisions. So
You're going to need to be louder too, I'm sorry. It's really hard back here.
okay, so what we want to know is the Supreme Court doing a good job? Right? We want to know, is it playing the right role in our system of constitutional democracy? So first we have to ask, what is the court supposed to do? And the answer is, it's supposed to be, in some ways, an umpire. We've got ordinary politics, that's the ordinary democratic process, and we've got some limits that the Constitution places on ordinary politics. And the court's job, basically, is to make sure that the ordinary political process doesn't go beyond those limits. The federal government and the states don't do things the Constitution forbids them from doing. Now this would be pretty easy if the constitutional limits were always clear and easy to identify. And some of them are. So each state gets 2 senators. The president has to be at least 35. Those are straightforward. But some of these limits are not. For instance, the Constitution says no state shall deny any person the equal protection of the laws. It's not clear what that means, and more important, once we decide that what it means is that states can't discriminate in an unjustified or oppressive way, which is what the Supreme Court has consistently said it means, it's not clear what kinds of discrimination are oppressive or unjustified. So sometimes it's hard for the Supreme Court to decide whether a constitutional limit has been crossed. And sometimes, and this is really the key point, someone else is better at deciding. So imagine Congress enacts a law, and the constitutional question is whether this law is within the commerce power. That's the provision that gives Congress the power to regulate interstate commerce. And what the Supreme Court has said about this is Congress can regulate any activity that substantially affects interstate commerce. So who's better at deciding whether some activity substantially affects interstate commerce? Is it the Supreme Court, which is going to hear this issue once in the context of a single case and has to rely on the litigants to inform it in the context of an adversarial legal process? Or is it Congress, which can hold years of hearings and ask experts to testify? The answer is Congress is better at that. Or what if the president decides that some action is necessary to protect national security? That will sometimes be the relevant constitutional question. Who's better at deciding what national security requires? The president, consulting with the CIA and the military, or 9 judges sitting in Washington, D.C.? There the answer is the president. So the first point is, sometimes the court is not best at deciding whether the Constitution has been violated. Sometimes the president is, or Congress is, or maybe a state legislature is. And what the court should do in those cases, usually, is back off. It should review the decision, yes, but it should review it deferentially. It should say, we're not going to strike down this law, we're not going to invalidate this executive order, unless you've clearly done something very wrong. Now, on the other hand, sometimes the court is better. Now, sometimes this is because the Constitution gives you a technical legal question. What's a bill of attainder, for instance? But more often, it's because even though Congress or the president or a state might be better at deciding this question, there's some reason to suspect that they won't answer it honestly. They won't be impartial. So we're asking, let's say, whether some form of discrimination is justified. It's a standard equal protection clause question. The state is putting burdens on some people in order to give benefits to others. And let's say the benefits go to the state legislators, the people who are actually deciding whether or not to enact this law. And the burdens fall on out-of-staters who can't even vote in state elections. Now, ordinarily, we might say calculating the costs and benefits of laws is something that legislatures do better than courts. But in this case, we would say you can't really trust the legislature. The democratic system is going to malfunction here because the benefits are going to a politically powerful group, the legislators themselves in this example, and the burdens fall on a weak group, one that has no voice in the political process. And in this case, the court should not be deferential. It should be suspicious. It should say, we're not going to let you do this unless you show us there's no other way to achieve some very important goal. And generally speaking, this process is what the court goes through. If you look at all of the complicated tests the court has created, they basically come down to the choice whether or not to defer to the judgment of someone else, like Congress, the president, or a state. And usually the court does it right. Usually they choose the sensible option. But not always. So now let's talk about some of these cases. First, healthcare. I'm going to talk about the constitutional decision here. And here we're talking about the individual mandate, where Congress requires individuals to buy health insurance. Congress justifies this as a means of regulating interstate commerce. So the question, as I said before, is going to be whether this is something that substantially affects interstate commerce. And, I said before, usually Congress is going to be better at deciding this. So you would expect the court to defer. But in fact, they didn't. They ended up upholding Obamacare and the individual mandate, but not because they said this is something that substantially affects interstate commerce, or Congress might reasonably have thought it affects interstate commerce, which is usually the question they ask. Instead, they ended up upholding it as a tax. They said it falls outside the commerce power. We don't believe that there's a substantial effect on interstate commerce here. Even though, for instance, uninsured people were going to emergency rooms and consuming $48 billion worth of health care every year, which they couldn't pay for, creating costs that were then shifted to other consumers or hospitals. So that decision, I think, the court failed to defer when it should have. I think the outcome is right, but I think it should have been upheld under the Commerce Act. Next up, marriage equality. So if you think about this in terms of equality, it fits the pattern that I was describing before. The state is discriminating against some group. Now that's okay if the discrimination is justified. It's okay, for instance, to deny driver's licenses to blind people. But it's not okay if the discrimination is unjustified or oppressive. Now, who's better at deciding whether some kind of discrimination is unjustified or oppressive? It's usually the legislature. They know more about what life is like in their state than the courts do. So usually the court should say, this is probably fine, we're not going to interfere unless you've done something really crazy. So if you're trying to say there's a constitutional right to marry your first cousin, or to marry someone who's younger than the age of consent in that state, you probably won't get very far in court, and you probably shouldn't. It's a weak constitutional argument. But sexual orientation is different, just like race is different. Because here we've got a minority that has been subject to a history of prejudice and discrimination based often on inaccurate and derogatory stereotypes. The legislature is not going to do such a good job here because it's likely to discount the interest of, or even just harbor animus against, gays and lesbians. So there's a pretty straightforward argument that the court shouldn't defer to the legislative judgment. There would have been a pretty straightforward equality decision that the court could have written. Unfortunately, Kennedy didn't do that. Kennedy decided to write an opinion that was more about liberty, which kind of blurred the issue and is harder to justify. But I think the outcome is pretty clearly right. Last up, Citizens United. So what's going on here is a congressional attempt to improve the political process by regulating corporate political expenditures. And the constitutional provision that we're dealing with is the First Amendment, which says Congress shall make no law abridging the freedom of speech. Now you might think that's simple, right? No law means no law, case closed. But actually the First Amendment turns out to be very complicated. Lots of laws abridge speech. Most of them are actually okay, like the law that prevents you from driving a sound truck around my neighborhood at 4 in the morning. So the First Amendment is not intended to make any kind of expression sacrosanct under all circumstances. What is it intended to do? Well, people differ, but a common understanding of why speech is so important is that it makes democracy possible. Free speech gives people the information they need to govern themselves, to make informed decisions about political matters. So one thing you might ask is whether the government is trying to suppress political speech. And And if you ask that, the regulation looks suspect, because that's exactly what it does. But the other thing you might ask is whether this law improves or worsens democratic self-governance. And from that perspective, it's a more complicated question. There are certainly respectable arguments that unfettered corporate influence on the marketplace of ideas is a bad thing. Corporations aren't people. What corporations want is not necessarily good for America. And there's no obvious reason that corporations, which are given a variety of special attributes that make them good vehicles for wealth accumulation, should be able to use those attributes to exert a disproportionate influence over the political process. And if you ask what I think is the fundamental question, who's better at deciding whether this benefits or harms the political process, the answer there is surely Congress. Congress is composed of elected officials. They know a lot more about the electoral process than the Supreme Court does. So in Citizens United, I think the court did the wrong thing. I think it should have deferred to the judgment of Congress, when in fact it didn't. So that's sort of the general way I like to think about Supreme Court cases. That's my quick take on these three areas, and I look forward to our discussion.
Thank you. You really did do it in 15 minutes. That's astounding. So let's, before we kind of go back and dissect some of that a little more, let's look forward. We are at the start of the new term. What do you think the most important issues are that are going to come before the court? And if you want to offer any predictions about what we'll be talking about as the most important decisions at the end of the term.
Well, I think we're going to get a big affirmative action decision. The court has been leading up to this for a while. It's been following a pattern that John Roberts likes to do, which is to start out with a relatively narrow but unanimous decision before he goes for the fences. And then it's usually 5-4, but he can say, look, we were unanimous, everyone agreed on this, I'm not being part of it. I think that the Roberts court is going to eliminate explicit consideration of race in affirmative action programs. I think that's what they've been leading up to.
Any thoughts on the question of state restriction on abortion clinics?
Well, I have lots of thoughts about that. I mean, it's a sort of complicated question about what the court has been doing, the way it's been intervening in the process here, whether it's actually done a good thing or a bad thing. Basically, the way that the court seems to be going now is it's applying this very fuzzy, unclear, undue burden test. States are allowed to do things that are not undue burdens. And it turns out that what's an undue burden depends a whole lot on who the judges are. The judges on the Roberts Court, particularly once Alito replaced O'Connor, are much stronger believers in the good faith of states. So they are willing to say that things are not undue burdens when previous courts would have. So I think what we're going to see is sort of a gradual creep of increasing restrictions, whittling away the abortion right.
The other thing that's going to happen in 2016, of course, is we're going to elect a new president. So we have a court where any number of the most important cases are decided 5-4, and also a court in which we have a fair number of justices in their late 70s or 80s. Do you think that this presidential election is particularly consequential in terms of the direction of the court for the next generation?
Yes, I do. I think it's very consequential. I think it's unfortunate that we have the system we do, where whether a president gets to replace a Supreme Court justice is sort of a matter of luck. It would be better, I think, if we had fixed terms, 18-year terms for Supreme Court justices, then each president would typically get to replace 2. But yes, so for a long time, the court has been pretty evenly balanced. And for a while there, you had Kennedy and O'Connor sort of in the middle, casting the deciding votes. Now you've got Kennedy in the middle, which is a somewhat different court. But for a long time, you haven't had opposite party replacements. You haven't had a Democratic president replacing a justice appointed by a Republican or vice versa. And I think almost inevitably we're going to get that in the next administration. So I think the court is going to tilt decisively one way or the other. And we're going to see exciting and interesting times ahead.
There's an argument that's made often, more so on the right, but in some ways it's shared by political scientists of different stripes. And the argument goes that the Supreme Court, particularly with respect to the Roe decision, really helped give birth to, no pun intended, the modern Christian right and the power of the evangelical political movement in America. The argument goes, I'm sure you've heard this many times, we wouldn't have as deeply divided politics and culture today if it wasn't for the fact that the court took the question about abortion away from the democratic process and decided it as a matter of constitutional law. How do you react to that? How do you feel about that?
Well, I think that that's quite plausible. I mean, I know that people differ over the extent to which that accurately describes reality. I haven't investigated the primary sources enough to have a really strong opinion on that. But certainly that's something that could happen. That doesn't necessarily tell you whether the court made the right decision or the wrong decision. It's a question of constitutional interpretation. Personally, I actually think that the Roe decision is pretty poorly written. I think there are much more convincing arguments to be made. As a constitutional decision, I think Roe's a pretty bad decision. But one thing you also could say is that Roe was actually a great gift to the Republican Party, not because it energized the religious right so much, but because it allowed the Republican Party to hold together a coalition of religious conservatives, social conservatives, libertarian conservatives, and corporate conservatives, not all of whom had the same view on abortion, and some of whom might have defected from that coalition if abortion were a live issue. But because the Supreme Court took that away from the political process, the Republicans didn't have to worry about the libertarians leaving because of pro-life Republican candidates, because they knew that it wouldn't get those policies.
So the effect could go both ways, is what you're saying.
Yeah, and what that suggests is that maybe the Republican Party, at least the mainstream Republican Party, doesn't really want to overrule Roe. So they might be happier actually with a situation in which what we have now is going on. There are increasing restrictions. Abortions get a lot harder to obtain unless you're rich or well connected. But Roe is not actually formally overruled.
So a couple weeks ago, we had a program, as you know, with Justice Breyer. And one of the, I think, most sort of poignant stories that the Justice shared with our audience was about a meeting that he had with the Chief Judge of the African nation of Ghana. And he said that the judge came and asked him a very simple question, simply worded question, but an important question. And that was, why do they listen to you? Why is it that the people with the guns, the people with the money, the people with the political power obey the rulings of the Supreme Court? Tells you a lot about the depth, if you will, of the rule of law as a concept in American, as a construct in American life, and how in many places that seems quite alien where people are used to decisions being made by force or by other means. But I posed this question to the Justice at the time. He's more limited in what he can say than you are. And that is that question of why do they listen to you and all that it implies, I think has become, particularly after the same-sex marriage decision, more a part of our own political discussion in this country. Right? So we have candidates for president of the United States who are talking about the Supreme Court not being final in some sense, and the prerogative of both the Congress and the president to define the Constitution for themselves. Lots of references being made to the fact that our greatest president, Abraham Lincoln, once did not follow, did not obey a Supreme Court decision. So do you see the potential for a fraying of that fundamental construct that the rule of law will be obeyed in our country based on the Supreme Court taking on and deciding these very controversial social issues?
I don't think so. And I say that not because I think our political culture is healthy, because I think it's not. I think we're very polarized, our government is not functioning very well. But I think that that would be such an extraordinary departure from our legal culture, our historical culture, our identity as Americans bound together by the Constitution, that it's unlikely to happen. Now, you know, there have been presidents who have more or less defied the Supreme Court. Andrew Jackson famously did this with the decision about the rights of Indian tribes. FDR, somewhat less well known, communicated secretly to the Supreme Court that he would defy an order to stop a military tribunal that was prosecuting Nazi saboteurs. This is something I discuss in a novel that I just published. But no president has ever defied an order from the Supreme Court. Abraham Lincoln actually did defy an order from a single justice. But when push comes to shove, if you've got the court ordering even the president as an individual to do something, the president complies. Nixon did that, you know, when it cost him his presidency. And I don't think we're going to see actual defiance of the Supreme Court.
But this discussion about the legitimacy of the constitutional interpretation coming from the court, particularly again on these social questions, is not limited to, you know, the Republican presidential debate stage. You have the Chief Justice writing in his dissent in the same-sex marriage case that, you know, while people, in his view, might be celebrating the decision, you know, quote, it has nothing to do with the Constitution. It's very extreme kind of rhetoric about his brethren. So do you see the polarization that you're talking about hardening on the court itself, and does that weaken the rule of law?
Well, I was surprised by that Roberts opinion. You know, I thought Roberts might go with the majority. I thought if he was a dissenter, he would try to write a dissent that would look good to history, to make the court look good. That was why I thought he might be on the dissenting side. And to say that the Constitution had nothing to do with it is just ridiculous. I mean, you could say the same thing about interracial marriage, right? Would you say the Constitution had nothing to do with that? It's absurd. Now, the more troubling opinion actually probably was Justice Scalia's opinion, in which he basically explicitly invoked the idea of defying Supreme Court rulings. He said the more decisions like this we issue, the closer we come to being reminded of our own impotence. By which he meant the court cannot enforce its decisions. And if enough people simply refuse to comply, then as long as the other branches of government don't back the court can't do anything. So Scalia's always been a bit like that. He's always willing to say, you know, the other justices are acting willfully and imposing their own views in the guise of constitutional interpretation. Roberts is usually much better about thinking about the court's institutional authority. It's something he cares a lot about. So I was very surprised to see that from Roberts in particular. But again, you know, I don't think we're going down the path to total chaos.
So let's talk a little bit about these two worldviews of constitutional interpretation. And obviously there are many shades in between, but for purposes of simplified discussion. It's fairly easy to articulate the strict construction, original intent kind of limited constitutional interpretation. I guess I would ask for your articulation of the broader interpretation that allows for decisions like the same-sex marriage decision.
Yes, absolutely. So this is something I've thought about a fair amount, and I've written about it. So if you're interested in my views, I have a book. It's called The Myth of Judicial Activism, which sets out the framework I gave you, and also more or less what I'm going to tell you about originalism, which is, I consider myself an originalist. But the important thing to understand is originalism is not incompatible with the idea that a case could come out one way in 1868 and another way in 1953. So it's possible, and I demand that everyone agree with me on this, because this is just true. It's possible to write a constitutional provision that directs different outcomes as times change. The example I use in the book is you could have a clause that says, while the senators are engaged in debate, they must wear the latest fashions. Tells them to do one thing in 17 89. It tells them to do something else in 2015. You could write a constitutional provision that's like that. Now, it's a separate question, do we have any provision in our Constitution that actually do that? Is this back on?
No, 1 second.
It's a separate question.
There we go.
There we go. It's a separate question whether we have any provisions in our actual Constitution that do that, but I think we do, and I think that the Equal Protection Clause is one. So if you look at what the court has always said from right after ratification about the Equal Protection Clause. Conspiracy.
Do you believe that the MSA is behind every curtain?
If you look at what the Supreme Court has said about the Equal Protection Clause, they've always said, like I said here, it prohibits arbitrary or unjustified discrimination. And then the question is, when people wrote that, when they ratified it, when they understood that they were putting into the Constitution provision that would prohibit oppressive, unjustified discrimination, did they think we were always supposed to ask, what did people think was oppressive in 1868, or did they think future generations would bring their own understandings of what was oppressive? And could go either way. The historical evidence that I have seen suggests to me, and I think it's the more common sense view, they thought that future generations would decide. Because after all, what were they doing? They had just fought a war in which some states engaged in a practice, slavery, that a majority of the nation thought was unjustified. They could have just prohibited slavery. They did. They could have just prohibited discrimination with respect to race, with respect to voting. They did that. Those are the 13th and the 15th Amendments. But in the 14th Amendment, they were trying to do something different. They were trying to write more generally. They put in this general prohibition on unjustified or oppressive discrimination. It seems very plausible to me that they thought, in the future, some states are going to do something that a national majority thinks is oppressive or unjustified. We want that to be unconstitutional, because we want this constitutional provision to knit us into one nation and stop some minority of states from doing things that a national majority thinks is unjustified, no matter what those things are. We don't pretend to know what they'll be, but we want the will of the national majority to prevail in the future. And that's really what has happened in all of the Supreme Court's equal protection decisions, up to and including same-sex marriage.
I want to ask about the area of national security law, which again is something we discussed a little bit with Justice Breyer. It's sort of, you know, common sense view of the history of the last 100 years that presidential power in matters of national security has continued to grow and grow. Perhaps the zenith being the Korematsu decision and the Supreme Court allowing the internment of the Japanese Americans. But looking at today and what could be cases before the court, the nuclear agreement with Iran, called an executive agreement rather than a treaty, potential constitutional question could be raised there. And our ongoing war, with that being the word that's used by the administration itself, ongoing war against ISIS, neither declared nor even authorized by Congress. So do you see the court at some point being willing to take a more activist role with respect to the power of the president in international affairs, or do you think that there will continue to be more of a hands-off attitude?
Oh, I absolutely think that the court is going to be willing to take a more activist role. So Korematsu, you could say, is the zenith of presidential power. Korematsu is what my novel Allegiance is about, although it's using Korematsu as a way to think about contemporary national security issues. I have postcards on the table over there. So thank you for asking that question.
It was not planned.
The interesting thing about Korematsu is, of course, you know, it's an anti-precedent. It hasn't been overruled, but it's a case that the Supreme Court looks at and says, we made a mistake. We let the executive branch do something in the name of national security that actually wasn't necessary, that in fact inflicted harm on innocent people. It was just a really bad idea. And if you look more deeply into the story of Korematsu, the other thing that happened is the executive branch misled the Supreme Court. So in the litigation, when they were making their arguments to the Supreme Court, they asserted things about reasons to suspect disloyalty among the Japanese American population that they knew were not true. So the Army had various ideas about short-ship radio transmissions and signal lights. The FBI and the FCC investigated these things, found out they weren't true. Nonetheless, the government's lawyers went to the Supreme Court and said, here's why. Here's why it's appropriate to suspect the Japanese Americans. And the Supreme Court really did learn from that. So actually, the summer before some of the post-9/11 cases were being decided, I was talking to Justice Souter. He was reading a book about what the executive branch had done in litigating Korematsu. And when the Bush administration faced the Supreme Court in cases about the government's authority in the area of national security, it did a whole lot worse than FDR did. It used to be conventional wisdom that wartime presidents don't lose in the Supreme Court. But Bush lost several cases about executive authority.
One last question from me, we'll open to the audience. We didn't hear your view on the other, perhaps most important Supreme Court case of modern times, the case that made George Bush president of the United States. What's your view about that decision?
My view is that Bush v. Gore was a mistake. I mean, I think it's hard to understand it. Well, it's hard to understand it except in terms of partisan politics, and that's very disturbing. Justice Souter was very upset by that decision. I think it probably played some role in his decision to retire relatively soon after, as soon as a Democrat would replace him. But I think that Bush v. Gore also has a little bit deeper lesson to teach, because the reason that the partisan instincts of the justices got involved was the 5 justices in the majority believed, I think in good faith, that they were facing a partisan attempt by the Florida Supreme Court to steal the election. And they were saying, this is judicial activism, we've got to get in there and stop it. Now, I think it probably wasn't, but what this suggests, the deeper lesson that I try to take away from Bush v. Gore, rather than saying it's just naked partisan politics, is it shows how the specter of activism can mislead us. So when the Supreme Court or any court issues a decision that we disagree with politically, it's very easy to say, those are activist judges, the Constitution must be on my side, they're being unprincipled, they're just imposing their policy views, and therefore we should do something to stop them. And that, I think, is a mistake with like the court packing plan that FDR had. It's a mistake with various proposals that people have been floating around now, and it's the very same mistake that the Supreme Court itself made in Bush v. Gore.
Thank you. Questions from the audience? All the way to the back.
You commented on Citizens United, that you didn't agree with the Supreme Court decision there. And if you look at a lot of polls that are taken, a lot of Americans, or many Americans, perhaps even also believe that there should be some curtailment of how much money gets put into politics. And I would say the similar case that I would, I'm guessing that your response to is repeal of the voting rights legislation. That despite the fact that it was passed and re-upped by Congress many times, the Supreme Court rejected it. And to the extent that they said, hey, we've got to do this because Congress has to pay attention to the people and we don't, was the part of the ruling. So what's a citizen to do? If there's these are two different cases where majority of Americans and majority of legislators passed the McCain-Feingold passed voting rights legislation, the Supreme Court overturns it.
Well, that's a very good question. My answer usually is, if you don't like what the Supreme Court does, don't worry too much, because in the long run, the Supreme Court follows dominant opinion. It doesn't stand against the other branches of government for that long. And if you were asking a question about social values, I would say, either remedies the ordinary political process or changing the minds of your fellow citizens. If you can succeed out there, the court is eventually going to come around, because it generally does. Now, Citizens United and Shelby County, the decision that strikes down part of the Voting Rights Act, are especially troubling because what the court is doing there is not just reflecting some value judgment or some understanding of the Constitution that lots of people don't share. It's also sort of interfering with the political process. So both of those decisions do have partisan tilts if you're asking who gets helped in the political process. And that's disturbing because, to the extent that the Supreme Court is helping out one party or the other, particularly in the presidential campaigns, it's going to affect who's appointing the replacements for the justices. All the same, I do think the political process is still going to work. Eventually, unpopular Supreme Court decisions don't survive, and I think ultimately Citizens United is not going to survive.
Please.
Yes.
Just a follow-up on that. Is the issue with Citizens United that corporations are treated as an individual and therefore entitled to free speech? And how might that be changed then through legislation?
Campaign finance is a complicated issue. There are a bunch of different decisions that work in interlocking ways. But yes, in Citizens United, basically what the Supreme Court was saying was that corporations have the same unlimited expenditure right that individuals do. And as I suggested, it's really not clear that that makes sense. If you believe speech is always good and more speech is always better, you might think that, but that's probably not true empirically. And so I was saying it's not all that obvious that corporations, which are sort of specialized vehicles for wealth accumulation and risk distribution in the business world, should be allowed to use the wealth that they accumulate in that way to exert this disproportionate influence on the political process. And there are a couple of things that could be done about that. One is we get a new president, some Supreme Court justices retire, the Supreme Court reverses it. That could happen. Another possibility is we get a constitutional amendment. Amending the Constitution is hard. It hasn't been done for quite a while. But back in the early 20th century, we had a bunch of progressive amendments that were designed to improve the political process and eliminate corruption and so on. So it happened. It could happen again. The other thing that maybe could happen is you could do this through corporate law. So people have been floating the idea, I'm not sure how far it's gone, but people have been floating the idea that states should just amend their corporate laws so that you get your corporate charter from the state of Delaware, say, and you get unlimited lifespan, which a corporation has, and you get the separation of ownership and control, you get your standard corporate structure. You get shareholders not being personally liable for the debts of the corporation, but in exchange for all of those things, there are some limits on what the corporation can spend its money on. And I think that would be constitutional. I think that would be okay. There might be a collective action problem because maybe this would make states that amended their corporate laws in this way less attractive to corporations, but if Delaware could do it, then the other states might go along. So it would be possible for the states that are creating these corporations to put limits on their powers, maybe.
So run for governor of Delaware. Might be the best approach for that. Please.
Do you think the fact that the court declined to use the interstate commerce clause as the basis for the Affordable Care Act decision will be used as a precedent in the future to apply it in a more restrictive manner than it has been today?
Could you repeat that?
Question basically was the court declining to use the Interstate Commerce Clause as the basis for upholding the Affordable Care Act. Does that signal a more constrained view of the Commerce Clause doctrine that could be applied to other things?
I think that that's a possibility. Certainly not the necessary consequence. The Affordable Care Act was a pretty unusual situation, and what the court relied on in saying the Commerce power doesn't allow this was the idea that Congress can't regulate inactivity. So circumstances in which Congress is going to want to regulate inactivity in the future will probably be pretty rare. If they want to, the Supreme Court has shown that they can do it through the taxing power. And even in the Affordable Care Act decision itself, it wouldn't have been that hard to find an activity to point to, right? You could have pointed to the activity of going to an emergency room and consuming $48 billion worth of emergency care every year, which, if you can attribute it to the group of uninsured people, and the Supreme Court said for some reason you can't, but if you can attribute it to them as a group, is certainly plenty of economic activity to be regulated. So I don't think it's going to mean that much. You know, it's hard to predict what a Supreme Court decision is going to mean until the Supreme Court has had a few more chances to explain what it means. And what it says in the future is probably going to depend a lot on who's on the court. And like I said, I think we're going to have an interesting and dramatic shift depending on which party wins the next presidential election. But my take on that is more that John Roberts was trying to give everything he could to the conservative challengers to the Affordable Care Act without actually striking it down, because he thought a 5-4 party line vote striking down the Obama administration's signature legislative accomplishment is going to make the court look partisan. And it was more important to him, I think he doesn't really hate health care, it was more important to him to make the court look like a neutral and principled form of justice than to strike this down. At the same time, he was trying to give the challengers everything he could, so he gives them this holding on the reach of the Commerce power. Of course, they ended up being bitterly disappointed and turning on it anyway, so it didn't really work, but I think that's what he was trying to do.
Please.
As a close observer of the court, I wonder if you would talk about the congeniality, the interrelationships that you have seen. There's been a lot of 5-4 decisions, a lot of minority opinions read from the court. How do you see the interplay among the justices?
So the question was about the relationships among the justices, and I clerked there in the 99-2000 term. I clerked for Justice Souter, and I was amazed, actually, at how good the justices were at putting aside hard feelings over past cases and maintaining collegial relationships. Justice Scalia and Justice Ginsburg are actually probably the closest two justices on the court. They're good friends, even though they disagree quite bitterly. Justice Ginsburg is pretty restrained in her writing, but Justice Scalia is always willing to call people who disagree with him, you know, not just stupid, but corrupt. And he does that all the time. I was working on an opinion once where Souter was writing majority opinion, Scalia was dissenting. He was saying, you know, that we were destroying American civilization, basically, and I was very upset. But Justice Souter said, well, you know, that's just Nino being Nino, and sort of laughed it off. So for the most part, the justices are pretty good, certainly better than the clerks, who were only there for 1 year. Certainly better than the clerks at setting all that aside and going forward and understanding that they're there for the long term and they have to serve with each other and get along. I do think sometimes there are decisions, Bush v. Gore as an example, that make some of the justices really question what they're doing there. You know, Justice Souter, I think, never really loved being a Supreme Court justice, but was really hurt by Bush v. Gore. But, you know, on the whole, their relationships are all pretty good.
Please.
If one of the justices on the conservative side would leave for whatever reason now, Obama then would have a pick. I don't know how he would ever get a justice approved by the Senate, and it would be vice versa. If a Republican wins the next election, how would the Republican then, if one left on the other side, get one approved? It seems to me they're so bitter that it would be impossible to get another justice approved.
The question really goes to the bitterness of the confirmation process in the Senate and the partisanship in the Senate and how that affects the future of the court.
Well, the answer is, you know, that's really just sort of the way the political process works, and that's the way the branches of government jockey back and forth. The president is going to put forward someone, the Senate is going to do what it does, and then if they reject that person, the president will put forward someone else. So it has happened that nominations have been defeated, it's happened that nominations have been withdrawn. You know, the president has a choice then. The president could take his case to the American people and say, Congress is stopping the Supreme Court from functioning, punish them, and then maybe people will call their senators. Or the president could say, you know, I overreached with that person, I'm going to have to go to someone more moderate, and then maybe that person will get confirmed. I do think, you know, you're right that if Obama got another appointment now, he probably wouldn't be able to get someone through, more or less no matter who he picked, just because it's so close to the end of the term that the Republicans would be like, we're going to play hardball, and maybe it'll hurt us a little bit, but it's worth it to delay this pick. If you've got someone making an appointment earlier on in their presidential term where it's clear this has to happen eventually, you know, before the president leaves office, I think it'll happen. it might be bitter. The board confirmation hearings were very bitter. And the first choice might not get through, but eventually I think it would happen.
Mitch?
That was very interesting, and in fact, when I was in law school, I wish I had you, the way you wrote it. But I guess the question I have, going back to the marriage equality decision, I think I was happy with the outcome. I agree with you, it probably could have been written a little bit better by Justice Kennedy, but I'm concerned about this whole issue with religious liberty or religious freedom, and I keep hearing. And ultimately, say a florist or a bakery says, we're not going to sell a cake to someone because it's a gay couple. Do you see a case like that coming to the Supreme Court, and how do you think the court might deal with it?
So
Is it coming in the agenda? I'm sorry.
Well, no, but it's been for appeals.
Okay, do you see the court taking that case?
So the question goes to cases coming out of the marriage equality decision, arguing that people's religious liberty is being violated if they are compelled in some way to participate in a practice that they don't agree with.
Well, that's an interesting question, and I do think that the court will hear a case on that sort of general topic. I think it's more likely to be a free speech case, though, because the way the constitutional treatment of religious liberty is now, after a Supreme Court decision called Smith, you have absolute protection for your beliefs, but as far as conduct goes, if the government has a law that is generally applicable, and so it applies to everyone, and it's about conduct rather than belief, they can prohibit you from doing something that you say your religion requires you to do, they can make you do something that you say your religion forbids you from doing, and your only remedy basically is to avoid those activities. So if you're a business and you have to discriminate, then maybe you shouldn't be in that business. And that's settled law. So as a matter of constitutional religious liberty, most of these cases are pretty easy. And unless the Supreme Court decides it wants to revisit Smith, there isn't really much of a question there. There is a question, though, with respect to compelled speech, because one of the things the Supreme Court has said with respect to the First Amendment is the government can't make you speak. It can't make you express a message that you might not agree with. So I think the hard case is sort of, where do you draw the boundary between speech and non-speech conduct? So is a florist protected by the First Amendment? Is a baker who's baking a cake, or is a baker who's writing a message on top of the cake? And I think where you draw that line, because it will be drawn somewhere. There are some people who are protected by the First Amendment. Where you draw that line is a hard question. It's not so clear to me that there is a hard religious liberty question, but I don't think that anyone has a religious liberty right to refuse service. There's a whole separate question about being forced to perform a marriage, and I think it's very unlikely that anyone will ever be forced to perform a marriage, because they're religious actors and they have a right to a government marriage, not a religious marriage. But I could also maybe see a case coming along those lines.
Please.
What's your view on the Hobby Lobby decision?
Question about the Hobby Lobby decision, which I'll let the professor explain.
So this is another case about religious accommodations and the ability of individuals or businesses to refuse to comply with generally applicable laws. And it comes up not actually as a straight constitutional religious liberty question, but because in the aftermath of that Smith decision, the federal government and also several states, and states have been doing this more frequently now, enacted religious liberty restoration acts, religious freedom restoration acts, RFRAs, where what they said was, if there's a law that burdens your exercise of religion, then you don't have to follow it unless it's the only way that the government can achieve a compelling interest, unless the government has something really important to do and they have no way of doing it that burdens your exercise less. And Hobby Lobby shows us, I think, that the Supreme Court is quite receptive to those claims made as a matter of statutory law. They're very willing to find burdens on people's religious liberty. So, if you say, it violates my freedom of conscience to fill out a form saying I don't want to provide this contraceptive coverage so someone else should do it, then they'll accept that. And they've also been relatively willing to find alternate ways for the government to achieve its goal. So, these are claims that I think are doing pretty well. The court is welcoming these claims. Myself, I'm not sure that I would decide the cases that way. Not all of them, but that's my take on what the court is doing.
Even though it's a private business.
Yes, well, private businesses are protected by these laws.
Please.
I'm not sure I understand where you come down on the issue of Supreme Court getting involved in politics. Now, we've seen it now in two very powerful cases. One, Florida, where they decided who the next president is going to be, and one about corporations allowed now to spend all this money against the individual who can't possibly meet that. That's an active operation. Do you see them as becoming a much more active Supreme Court in politics?
Question is whether or not the Supreme Court decisions, particularly in the Citizens United case and the Bush v. Gore case, indicate a court that's really involving itself in partisan politics.
Well, I try not to attribute Supreme Court decisions to partisan politics unless there's no other alternative. So, even Bush v. Gore, I try to come up with a little spin on it, saying it's not just partisan politics. And, it's undeniable that there's a divide on the Supreme Court that sort of maps onto partisan politics, and it has something to do with the party of the appointing president. But I think that it really comes down to the justices' worldview, which makes them more sympathetic or less sympathetic to certain people, or makes them more or less ready to see certain threats as real threats. So Justice Roberts, for instance, I think is very comfortable with corporations and doesn't think that corporations are going to do bad things. And he's apparently more worried about in-person voter fraud. So if you look at voter ID laws, not a lot of evidence that the problem they're supposed to be fixing actually exists, but the Supreme Court said, yeah, we think that's a good faith attempt by the states to improve the legislative process. The electoral process. Which is funny, because they're so suspicious when it comes to campaign finance reform. They're like, no, we're not going to let you monkey with the electoral process. Even though the evidence there does seem to suggest, people think at least, that money corrupts elections. You might think they would show greater deference to the views of the public on that. But so the short answer is, yeah, the Supreme Court has issued a bunch of decisions that I think undermine democracy. And that's bad. I would say I don't think the Supreme Court should get involved in politics at all, except that, one, it decides politically salient issues because the Constitution is relevant to them. And two, sometimes the court can improve the political process when it strikes down poll taxes, for instance, when it eliminates white primaries, for instance. So there are some judicial interventions in the political process that I approve of. It's hard, I guess, to come up with a very principled way of saying when the court is improving things and when it's making things worse, because plenty of people out there will tell you Citizens United makes things better. Now we have more speech. Shouldn't corporations be allowed to speak just like anyone else? Because if you don't like what they're saying, just don't listen or don't believe it. I'm not so sanguine about the effect of vast amounts of money sloshing around, but what it comes down to is sometimes the court can do a good job of supervising or improving the political process. So I wouldn't, for that reason, say I wanted to stay out of politics entirely.
Last question, please.
In the Kim Davis case, where the Supreme Court decided to give her 2 weeks of unpaid, do you think it was right to do that so that she would basically work in religion and a government office?
The Kim Davis case.
Well, the Kim Davis case is very interesting in a number of ways. What I would say about the Kim Davis case is, in part, it's an illustration of the Hobby Lobby phenomenon, which is governments are generally pretty accommodating. And in the Hobby Lobby case, the government offered accommodation after accommodation. Each time they offered one, Hobby Lobby said it's not enough. And Kim Davis has been doing basically the same thing. So she's offered the option of just taking her name off the forms, and then she said, no, it has to have my office to be not on the forms, and she's doing various things to the forms that her office was issuing in what seemed like an attempt to make them not valid marriage licenses. the big takeaway from the Kim Davis case, I think, is claims of religious liberty aren't always bad, and forcing individuals to do things that violate either their religious beliefs or their deeply held moral beliefs is not something that we should undertake lightly. But it's very important to think about who this person is and what they're doing. So if you're an individual sitting alone in your house, not messing with anyone else, and the government is trying to make you violate your religious beliefs, then I think you have a good claim. If you're a business and you're out in the public sphere and you're operating in the marketplace, I think your claim is weaker. And if you're a government official and your government has an obligation to administer the law without reference to religion, then I think you're in the weakest possible position. So Kim Davis' claims of religious liberty, maybe they could be accommodated. If she's willing to just not issue the license herself, maybe the state could say, okay, there's more than one clerk, someone else will issue it. That might be totally fine. But she now thinks that her professional identity as a government actor is sort of bound up with her religious conscience and her religious liberty, and that's where I lose sympathy for the argument.
Before we adjourn, a question on a related but different topic. In your view, could your great-great-grandfather be elected President of the United States today? And if so, in which party?
I think he could be elected as a Democrat.
We're adjourned. Thank you, everyone.